Do your homework? Let's actually do it. This post is a perfect example of cherry picking one sentence while ignoring over 150 years of constitutional law, Supreme Court decisions, and the actual rules for interpreting treaties. Yes, the English text of Treaties 6, 7, and 8 contains the words cede, release, surrender, and yield up. No one disputes that. What this post hides is that the Supreme Court of Canada has repeatedly ruled that treaties cannot be interpreted by reading a single clause in isolation. In R.V. Badger 1996, the Supreme Court held that treaties are not ordinary commercial contracts. They must be interpreted liberally in the sense that indigenous peoples would have understood them when they were signed. The court also ruled that ambiguities must be resolved in favor of indigenous peoples and that the honor of the crown governs treaty interpretation. In R.V. Marshall 1999, the court confirmed that oral promises made during treaty negotiations are legally relevant. The written English document is not the whole agreement. Crown representatives negotiated through interpreters with nations that had different languages, cultures, and legal traditions. Ignoring those oral promises distorts the treaties. In Mikisew Cree First Nation v. Canada, 2005, the Supreme Court confirmed that Treaty 8 did not give governments unlimited power over treaty lands. Even where the Crown has rights under the treaty, it must act honorably and consult affected First Nations. In Haida Nation v. British Columbia, 2004, and Taku River, 2004, the court established that the Crown has a constitutional duty to consult and, where appropriate, accommodate Indigenous peoples before actions that may affect their rights. If all rights had truly been surrendered forever, there would be no constitutional duty to consult. In Delgamuukw v. British Columbia, 1997, the Supreme Court confirmed that oral history is valid evidence in Aboriginal rights and title cases. That directly contradicts the idea that only the English wording matters. In Tsilhqot'in Nation v's British Columbia, 2014, the Supreme Court recognized Aboriginal title to land for the first time in Canadian history. If Indigenous title had been universally extinguished by the words cede, release, surrender, and yield up, that decision would have been impossible. Most importantly, Section 35 of the Constitution Act, 1982, recognizes and affirms existing Aboriginal and treaty rights. Those rights are part of Canada's Constitution. If treaties had eliminated every Indigenous right forever, Section 35 would have nothing left to protect. This image is also misleading because it implies all land in Canada was permanently ceded. That is false. Most of British Columbia was never covered by the numbered treaties. Modern treaties continue to be negotiated because many Indigenous nations never signed treaties surrendering their lands. The treaties were intended to establish relationships between sovereign peoples, not simply to transfer land like a modern real estate sale. Many First Nations have consistently maintained that they understood the treaties as agreements to share the land and live together in peace, not to permanently surrender their identity, governance, or all future rights. So before telling others to do their homework, read R.V. Badger, 1996, R.V. Marshall, 1999, Delgamuukw, 1997, Haida Nation, 2004, Mikisew Cree, 2005, Tsilhqot'in, 2014, and Section 35 of the Constitution Act, 1982. The Supreme Court of Canada has already made it clear. Treaties cannot be reduced to one highlighted sentence in an English document drafted by the Crown.